Welcome, folks, to our international podcast, Beloved Belt. Let us know if you're hearing us loud and clear. Debbie Owenkirk, good to have you here. Michaela Andrews, Coach A K. Debbie Owenkirk. I see Glycis, Bingo Byrne. Good to have you here, folks. Y'all can tell me, we get pregnant to resign. Y'all can tell me, soon your visa was lifted. Moment of Shigan, the is coming. Resignation, take one. Private life, take one. We got it made. As it were. Visa which travel to the UK? British Prime Minister. Mr. Listen, so don't come around with funny. See you later, alligator, Jim Cameron. Listen, I can see you outside. We can see you folks outside. That is where we're going to see you folks. Taz Thomas. Good to have you, Taz. Wish I had the bell. Taz saying ring the bell. Wish I had the bell. Folks, I'm privileged to have Julie Finance here with me. I'm going to do all this work on the podcast to you.
Oh my goodness. I mean, here I am, in my comfort zone, you know. I was just going to leave the work on you. Hey, folks. Good day. How are you doing? Hope all is well at your end. Hope you're having a fantastic day thus far. If I can put this over, I see the police on the road putting off these things off the buses shared. Just on a side note, you know.
That's the operation that's happening. That is the operation that is happening. You know, there's a road safety campaign that has been launched, and that is all part of that road safety campaign.
And the boom boxes and so getting out, you know, all the things. What's going on at your end, guys? Let me know what's up.
And what's for lunch?
Liz gone.
Believe it or not.
Before Liz could settle in, Liz gone.
Liz gone. So we've all been fun. We've all been doing it.
June Cameron, how are you? I hope all is well at your end. Glycis Mingo Byrne, good day, Glycis. Hope all is well at your end. I see Osman Hodge joining us this midday also. And Lyndon Carmichael. Hey guys, how are you doing? Good to your end.
Excellent.
Doreen Clark says good afternoon, my fellow Guyanese. Good afternoon to you too, Doreen. I hope all is well at your and Claudette Lewis. Hey Claudette, what's going on?
Claudette too?
And Gordon says good day, everyone.
Good job, Claudette.
I see Taz Thomas and Kurt Paris. They're also on and watching right now. They're commenting, but I call the name. You see, I can get these people in trouble. That's in countries. You know, because these people are at work. Actually, it's probably their admin that.
Oh, yes,
you know, using the pay, you know. So again. So I'm just going to put that out there as well. Winston Henry, good afternoon to you. How are you doing? Rosie, Leander, good afternoon to you guys. I'm hoping all is well at your end. I hope that you're all safe. Margaret Nelson says, Director of Philosophy Finance and shared every Duncan. We there. How y'all doing, good folks? We outside. There's some power. Boots on the ground. Ping. Two excellent now. David says, look at the front new road. I don't know if the road is new or it's a road with a new name.
Now you did three.
A new road name on an old road. What's going on? I see Basil Clark, or should I would say Basil Clark.
Basil.
That way, hey, Roxanne. Hope all is well. So I'll skip a set. Good afternoon. Rena Cummins, hey, how are you doing? I hope all is well. Terrence Bitten. I see Tom Thomas said shared every dog, and someone said on Facebook that I just now there I will be one of the cash grant for the UK trip.
Working on that.
Tell smart, tell smart. Marine to Chester Paul, pace and power, Marine.
Her is trust I done with this.
Yeah,
he's coming here.
Listen, I can't take anymore.
You go three, Just up. I work for that.
Gwyneth Anderson says good day below the belt family, and Peter Noble is saying hi to everyone. Also, then Zandy Alec Boom is on this afternoon with us as well, and Stan Boyd always says boom. Strangely, Alec Boom does say boom, but Stan Boyd does.
Hi, Dr. Alex.
AG must go, says Doreen Clark.
Hi, Dr. Alex.
Doreen, if you went on this protest line, girl. AG must go. The man make the CCJ change when they considering a policy change when it comes to whether or not they can send these results ahead of the actual ruling. Send the ruling documents.
Yeah, it's so embarrassing. It's so embarrassing, and
it would be embarrassing, Chad, if they only put that in place for Guyana. It's just
so embarrassing.
Everybody else forgets it, except Guyanese.
Yeah. Yeah. But that is strange in a way, because it's not kind of what the petition was about. Why not hold the whole petition? Because one respondent, wasn't served on time.
Yeah. But he can get a judgment before time, and he's stopping every knockout.
And affecting so many people.
Yeah.
Wow.
The integrity of the court is under question because of that action.
Just wow. Just wow. Folks, welcome to our program today, State of the Nation, State of the Region. When we talk about Anil, we're going to deviate from our theme a little bit. We can talk about the wider region of the Caribbean, and let's really say how they can be impacted.
Correct.
That is foolishness. And last night's program had so much content. We want to share back some of that with you today, because it's worthy of a second listen. Worthy of a second listen, folks. We're so happy that you guys are here to share the light, smash that emoji. The last day we had, smash that emoji, but we haven't done that. I've completely ended my sentences, because I talk so fast.
But I didn't get that shit.
I talk too fast. I do a lot of things fast.
So what you're talking about in the studio today?
But we talk about state of the region today. That's not what I'm talking about.
State of the region.
State of the region. Oh, the Caribbean will not be the same again after and the land will It will just not be the same again. It's an embarrassment, It's an embarrassment.
Good afternoon, and Elizabeth Kit. I hope all is well to your end. I'm seeing you there, not missing you there at all. Yeah, it's quite an embarrassment, like we said, because even we look at this from the external point of view, and you say that Guyana here is being portrayed as the AG's office here in Guyana being portrayed as a unit that cannot handle confidential information. So if they can, they definitely need to have a shake up there. Who's next in line, man, Cheryl? Who could be a good AG?
That's a difficult one, because if you think about
we gotta start having conversations.
Yes, we have this conversation. Now, you made a point yesterday, a very valid point too, that you think some people are fools, and then they open their mouth and they remove all doubts.
Yes.
And says Gunnar has been a good candidate up until recently. So let's take him off. You have the parliamentarian, what's his name? Datadin. But then Datadin, I remember that issue there with the electoral issue at Hatfield. Right? Because a woman felt very threatened. Right? Wasn't Datadin there on the step?
I cannot remember, but what I could remember.
My businesses.
Like I thought.
When you first get in, you must know the job in jeopardy.
I was thinking about Datadin for a little bit, but then I said, you know what? Since Datadin is in Parliament, he seems to be regurgitating the same speech every single time he has his present for budget. It's like he just cut this speech and just change up a few words and bring back the same. I said, no, man, Datadin, you make him a handful. Could have got in line to take over Anil work. But nope. Unless the word Dean, good day to you. Hope all is well. And is it Yonet Elias is on with us also? Hey, Yonet, and Velma Adams is also on with us. We have a very, very good combination of folks on with us this edition. Hit it, smashing that emoji.
Please do,
sharing the screen.
Yeah.
June said yes, he was there. Right?
In live and living color, he was there?
That's what June is saying. I don't know.
Excellent. Well, folks, we want to talk a little bit about what transpired in court yesterday, both on the substance of the petition and also on what transpired after that lengthy discussion the justices had with counsel on all sides on and posting content of that judgment on his Facebook page before the actual decision was handed down. And last night we had on our program Selwyn Peters, and we had international lawyer, let me preface by saying that, international lawyer Selwyn Peters, and also senior counsel Royce Ford. Folks, it made no point having them back on the program today. Suffice to say that we want to give to you the part of the program last evening where we engaged both of them on the issue of Nandalal's conduct or misconduct, and also what the CCJ said about the petitions. And both men had a lot to share with us, folks. If you didn't have a chance to listen last night, now is the opportunity. And if you did, we can only reinforce some of the things you should know or you know already. Guys, because we not only listen for entertainment value. When you talk to your family, you talk to your spouse, your brother, your sister, your kids, these are the issues you got to raise. When you talk to the people in your street, your neighbor next door, you have to let them know what's happening and be able to articulate issues. So even if you heard it before, we want to ask you guys to take them and listen so much. I listened back to it again, and I was there spellbound, by what Selwyn said last evening and was there. And I hope that you guys feel the same. There was so much content coming out and their own interpretation and rehearsing what the court said and rehearsing even some parts of that judgment. And here in this first instance, we're talking with, again, international lawyer Selwyn Peters, about what transpired in the court yesterday, what guidance should take away from it, and to make sense for us on the conduct of the AG. And then we're going to put in Royce there later on in the program. Julie, you want to add something before we go?
No, I think their discourse was on point. I just want us to get into it and then come back around to have a discussion of our own here today.
Precisely, that's what we're going to do.
Let's do that.
So we're going to circle back at the other side.
Let's make sense out of what went on and there's nonsense.
Allow the professionals to make sense of this, folks.
Well, the court wrote 86-page and 84-page decision in this matter, but it boiled down to how they read Article 163 of the Constitution and also the Election Validity Act. So they felt that Article 163 of the Constitution and Section 3, subsection 1 of the Election Validity Act provided exclusive jurisdiction to the High Court, and that the Court of Appeal had no jurisdiction to entertain this matter. Justice Anderson said that if there was any appeal in this matter, which is arguable, it could have been brought to the full court itself rather than the Court of Appeal. So they said that because the matter was brought to the wrong court, it was void.
And again, Selwyn, this isn't the substance of this petition, Election Petition 99. This is the substance of it.
No, it's not even the substance of it, and it's so. This case is so unfortunate in so many respects, because it's interesting that the opposite side was able to use and non-compliance in respect to someone who was on the same side as the petitioners. So essentially, David Granger signed a date of service that was out of time. So he signed the 25th as opposed to the 20th. And, you know, there was a whole bunch of affidavits and so on that were filed before the Chief Justice. She didn't accept them. She accepted what was on the face of the application itself, which was...
And that little thing was it.
Yeah.
When it's not about impersonation, who there are people who voted. None of that was in question. None of that came up because that's the substance of the case. All of these ballot boxes that didn't have statutory documents, none of that was discussed. Is this 25th as against the 20th?
That's right. And it is possible, as the argument went. Oops, I wonder what's going on. It is possible that it could have been a slip or error. It could have been a slip or error, and people sometimes make slip and errors, and certainly that was exploited to deny justice, to deny the hearing on the merits of an election petition. So this is another election petition in Guyana that went down the drain, in the sense that only one election petition in Guyana was heard on the merits. That was the Esther Pereira case. No other election petition has been heard on the merits. They've all been dismissed for any number of reasons. And that certainly doesn't bode well for democracy. I mean, the court wrote very flowery reasons, 84 pages, speaking about democracy and how the Constitution should flow and arise. But there's no life to the Constitution if you have an election and someone filed a petition, regardless of the merits of the petition has to be heard. The petition has to be determined on the merits. We just had election in Kenya, and the Supreme Court of Kenya, a 9-member bench, was able to hear that election petition in lightning speed and render a decision so that William Ruto was appointed or proclaimed as president, where, Raila Odinga was fighting really hard to say he won that election. But the election petition was heard. It was a full trial, and a determination was made. In Guyana, you don't have that. You have this election petition now dismissed a little over 2 years at the final court. And then you have on November 1st, the other petition that we're appearing in, 88, is going to be before the Court of Appeal for a case management conference.
It's quite interesting because you had 5 justices, as you articulated, who felt that once the Chief Justice ruled, there was no appeal to that. You have 3 of them, and then 2 of them said that the litigants could have appealed to the full court. We were made to understand, if our reading of it is correct, that you talk about this flowery language about democracy and all that. Justice Jamadar was one of those justices who espoused all of the virtues of democracy. But at the end of the day, this doesn't look like the will of the people, coming out here, because we ain't getting to the main issues, Selway. We ain't getting to them.
We're not getting to them, and it's, but the thing about it is, certainly it goes to show, really, Mr. Duncan, that in these cases, we have to dot the I's and cross the T's very carefully. I'm litigating at a very high level in Canada, litigating at a very high level in Guyana, and too often people take things for granted. You have something to be filed by no later than October 18th. And the judge is writing at the end of the day on October 19th, asking where are the documents that you're supposed to file. I found myself in that situation today, where a judge is asking where are the documents that were supposed to be filed yesterday. And I, as one, the lawyers haven't even seen the final document yet. So sometimes, even at a high level of litigation, lawyers cannot get their act together, and missing timelines. You cannot even miss a day. You're supposed to you're supposed to get your stuff ready at least a few days in advance, so that one doesn't run into these difficulties. So, I'm not criticizing any of the lawyers in this case. I don't want it to come across that way. But I mean, certainly, the errors that brought us to this stage could have been avoided, and sometimes we have to confront that, because had the petition been filed even a few days earlier, that could have been avoided. I mean, and then we didn't have and then there's no affidavit from David Granger explaining what the slip or error was and why that slip and error occurred. So, I mean, quite frankly, sometimes we can be our own worst enemies in these cases. And I know a lot of people are disappointed, but
and rightly so. And rightly so, because again, none of the allegations that were put forward that the PPP, in fact, were engaged in some nefarious activities in this last election were able to be ventilated in the court. It's all technicalities. Who gets served late? Who is a right respondent? Who isn't? Those kinds of technicalities. Selwyn, Attorney at Law Peters, when the Guyanese people hear this, they're now trying to make sense of it. Those at home, abroad, people in the Caribbean too, who've been following these issues and internationally, what do you think should be the takeaway from all of this? You're talking about litigating at a high level, and you look at this, the technicalities as against the substance. What should people take away from this process?
I mean, the takeaway from the process is that, these cases are hard-fought litigation. And sometimes, especially in the Guyana context, given that only one election petition has ever been heard on the merits, we have got to get it right in terms of ensuring that all timelines are met, that, we're careful as to which court is appealed to. We're careful as to jurisdiction. We're careful to serve and file in the right court. Everything has got to be on point, because if something falls off the rail, the opposite side will exploit it, and the court may well find favor with the other side to not deal with the substantive merits. I mean, in some of these cases in Guyana, the courts seem not to want to deal with the merits of these cases. Look at Paul Slow case that has been going on. It's going on to the second year. I mean, we have not gotten to the merits of that case, and the opposite side has been bringing motions to not have this case heard on the merits, and they will exploit anything. And the election petition, a slip on the part of respondent number 2, David Granger, certainly led to the exploitation of this in a big way. And certainly, because of the exclusive jurisdiction of the High Court, and the appeal that was filed to the Court of Appeal, the court said, well, hey, the decision to appeal is a nullity. And, the appeal is a nullity, and the decision to appeal to the Court of Appeal is a nullity itself. So, it's just, I mean, you find yourself down in a rabbit hole.
Yeah. Attorney at Law Peters, we were talking earlier on about litigating at a high level, and certainly the learned Attorney General has litigated before at a high level. But last evening we saw a very, very strange feature. The Attorney General put out on his Facebook page that the case was decided, and here is how it was going to come down. The only thing with that was that the CCJ had not yet issued its judgment. They took very harshly to that today at the CCJ, as they were actually then handing down the decision for the first time to what the Attorney General did. Justice Anderson talked about breach of confidentiality. Justice Rajnath Lee talked about the damage that could do to the court, and perhaps has done to the court. And not only did they demand in a very strong way an apology out of the Attorney General, but they say they're going to still meet, because all the things, there must be, consequences flowing that are greater than that. What happened here?
Well,
Attorney Peter.
Well, look, I mean, what the Attorney General did, and that is his page. He's the one that goes on there every week, or sometimes more than once a week, with his issues in the news program. That's his primary page. That's not a Government of Guyana page. It's a page controlled by him. The decision of the court, the Caribbean Court of Justice, was sent to lawyers. It wasn't sent to anyone else. And when it was sent to us, it was sent with a strong notice that confidentiality applies to this draft judgment until it's released by the court at 10 a.m. on the 19th.
That was specifically stated.
Yes, so it was an undertaking to keep it confidential. And the breach of an undertaking to a court is no small measure, especially when you're talking about the chief law officer of the state and the leader of the Guyana Bar. And I don't know if you heard, but I was one of the speakers to that this morning. And I spoke of that this man is the leader of the bar. He's the second Attorney General in the Caribbean region that found to have been in an ethical slip. The first one was the Attorney General of Trinidad, who swore an affidavit that wasn't true. This one here breached an undertaking to the court by publishing the substance of his decision and the result reached, despite an undertaking that he should not do so. It certainly put the integrity of the court at risk, and I agree. I mean, one only has to go to your page to see the comments that some of the readers left. They felt that the court was bought out by the PPP. They felt that that no other Caribbean state should join that court because it's compromised. Yeah. Some very, very caustic comments
which give rise to this phrase, bringing the court into disrepute.
Indeed, and that's the exact term that I used when I was speaking about the Attorney General's conduct and why that apology is not acceptable and should not be accepted. It certainly brought the court into disrepute. It lowered the court in the estimation of right-minded people, because obviously yesterday my inbox for emails, WhatsApp, and everything was filling up, because people, when they saw that screenshot from the Attorney General's page, was writing me to ask me if it was true. Some of the activists didn't even sleep last night. They were writing and ringing me down and ringing Royce-Dale down to find out, well, what's up? What is going on with this? Whereas he could have certainly kept it to himself like everyone else.
Interestingly, the Attorney General was a no-show at court, and the Solicitor General said that it was an administrator for the Attorney General, but that is, even to me, is to add fuel to the fire, because as if what you were saying, you have said to us that this was sent to lawyers in confidentiality. Then what would an administrator for your page be doing with that information?
Yes, and how did
that would be even worse?
And how did the administrator come into possession of it? Because this is a man. The Attorney General, the confidentiality of a court decision that's embargoed is equivalent to a state secret.
Yeah.
It's equivalent to a top secret document.
So this is not a fellow lawyer on the case posting on your Facebook page. It's an administrator, according to him, if he is to be believed, somehow got possession of this information and posted it. Interesting.
If it wasn't this serious, if it wasn't this grave, it would have been laughable. But it brings into question that man's judgment. It brings into question his judgment. It brings into question his proportionality, because the stuff that the Attorney General of Guyana does on his Facebook page, his issues in the news page, he could not have gotten away with it in Canada. I'm a lawyer here in Canada. I'm a lawyer in Trinidad, and I'm a lawyer in Guyana. I can say in full confidence that when my colleagues listen to the Attorney General of Guyana on his issues in the news features that he have, they scratch their head in awe. And I let them listen to it because I want them to see the sort of behavior that passes in Guyana from an Attorney General. And so, because he gets away with it, no one dared to tell him anything in Guyana that you're wrong, that your behavior is unethical, that you're crossing the line. He pushed it with the Caribbean Court of Justice, and he got called out in a major way.
Court and they said there's going to be more actions.
Yes, and the court would never look at him the same way. Lawyers would never look at him the same way. His colleagues would never look at him the same way because of that breach of confidence.
Which brings me to my my other question. What do you think would be the natural consequence flowing from something like? I mean, it seems almost unprecedented.
Well, it is unprecedented at the CCJ. I think the entire protocol at the CCJ will change. They released
thanks to the Attorney General Anil.
Yes, they released the decision the day before. I think they may simply release the decision about 15 minutes before it's released to the public, and they may not release it by sending it by emails. They may simply, you may have to log into a confidential portal where you can't even print it. You simply have to read it there and make notes from it, but you couldn't print it, you couldn't download it or anything like that. And that would be more of a surefire way to govern confidentiality. But the Attorney General has to really account. He has to take responsibility for it. That is his personal page. He cannot blame some Facebook administrator that administers his page. That is just laughable.
And has a confidential document too.
Yeah, it's just laughable. I mean, the question that you have to ask: does the Facebook administrator have access to cabinet confidences as well? Do they read the cabinet documents, the minutes of cabinet meetings, all those documents that are secret? And
pretty interesting.
And is it
pretty
possible,
interesting?
And is it possible that at some point, because they don't like a decision that was voted on in cabinet that may have been in favor of Priya or somebody else, it gets published on somebody else's page by error because the Facebook administrator saw it and nobody got to call this, and I put it in quotation mark, this Facebook administrator.
Wow.
This Facebook administrator thing is laughable.
Attorney Peters, you work internationally. I mean, give us that broad view of it. Do you see things like this? I mean, had this been any place else? We haven't heard the final word from the CCJ, and they were very specific. We don't have the time because of the other matters they were dealing with to deal with it comprehensively, but we're going to hear from them shortly on it. What would be perhaps a natural consequence of this in other places?
Well,
this breach of trust and confidentiality and bringing the court into disrepute.
Well, he would have had to resign. He would have been fired. I mean, look what the Trinidad Law Association brought we had a whole big meeting about the Attorney General. And there was a vote on whether the Trinidad Law Association should write to the president so that this man could resign. In Canada, we had an attorney general who picked up the phone and called the chief of police because he was involved in a traffic stop and he was forced to resign. You know, the attorney general of Guyana's conduct is much more graver. And certainly if he was in other jurisdiction, he would have had to resign. I mean,
I think you hit the nail on the head, Attorney Peters. He has done it so often and gotten away with it. The Guyanese people don't realize the gravity of what took place yesterday afternoon in that simple post.
Yes, and I realized it as soon as I saw it. I realized the gravity of the post because, I mean, certainly you were concerned about it. You know, it was brought to the attention of the leader of the opposition, the Honorable Aubrey Norton. It was brought to the attention of many of the members of Parliament, the Honorable Amansa Walton Desir, and they were all calling to find out what was going on. You know, they were all concerned about that post. So, and you know, people were commenting on Facebook. You know, it could have caused hysteria and panic in Guyana.
I think that is what troubled the court, if anything else.
Yes. The implications, the court has recognized that the implications of what happened there was grave, because this was not an ordinary case. It's a very sensitive case, and it's a case that has to be treated, you know, with the diligence, with the prudence, with the sound judgment and confidentiality that it deserves.
Yeah. The jury isn't out on this one, Attorney Peters. The justices of the CJA were very specific and very clear with what they said today, and none of that augurs well for a country like ours. And we have an administration here that won't do anything.
Well, it doesn't augur well because, of course, you've heard the comments of Justice Witt. You know, he was concerned if you can't trust lawyer, and Senior Counsel Ford is on, by the way, so you might as well get him so he can get a
Yeah, let me invite him. Sorry about that. Senior Counsel Ford, welcome.
Hi, good evening, Sherrod. Good evening, Selwyn. Good evening, members of the public.
I know you've had a busy day, sir, and thank you, Attorney at Law Peters, for spending some time with us this evening to make sense of all that transpired during the course of the day. We've been picking the attorney's brain on the outcome of the case. You can chime in there for us, and also this other fiasco with the Attorney General and releasing this information a little too early, and the court not taking too lightly to that at all. Go ahead, sir. Jump in at any point.
Sherrod, I deal first with the release, the improper, unauthorized release of the judgment by Nandalal. You know, Sherrod, I've been listening to yourself and Selwyn describe it as a grave act by him, but I just want to add that by any measure, it is an act of misconduct. It's a fundamental act of misconduct. The court recognized the degree and the gravity of that act, and I believe the court took it very seriously. As you indicated, Selwyn indicated, and yourself indicated a few moments ago, the court planned to come back and to deal with the matter a bit more. But what cannot be denied from this entire fiasco is that Nandalal singularly, personally, would have embarrassed not only himself, he would have embarrassed the office of the Attorney General of Guyana. It's a very high office in the Constitution. It's the only office other than the President and the Prime Minister that is specifically provided for in the Constitution, the Office of the Attorney General. And he has embarrassed this country. the explanation offered by Solicitor General Hawk was in itself was 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 ludicrous. It was quite ludicrous. There is no way, Sherrod, that a judgment of this nature could come to the office of the Attorney General Chambers and simply be taken down, printed, and such a statement put up on Facebook by an administrator of the account. It doesn't carry any ring of logic. No one will seriously believe it. I don't know if you observed the justice's face whilst Mr. Hawk was saying his little fable there, but that is the sort of story, that is the sort of embarrassment that this country would have suffered continuously from August 2020. We've had many instances where the president himself would have done similar acts to embarrass this country. Now, coming to the judgment itself, Sherrod, the judgment is a very profound judgment in the sense that it is the first time, I believe, an appellate court would have decided these issues. It is quite a disappointment that the decision went the way it did. I look at the judgments of Justice Jamadar and Justice Barrow, and clearly they articulated a different view from the justices Anderson, Rajnath Lee, and Witt. It is their view, based on the importance of the appellate court exercising a supervisory jurisdiction of the court, and in the entire interests of justice and rule of law under the Constitution. And I believe I recall a specific part of Justice Jamadar's judgment when he said that it is inconsistent with the rule of law to allow a government to come to power, an election petition to be dismissed, and the courts to be disarmed by an interpretation of the Constitution that denies the court the right to verify whether an election petition could have been dismissed lawfully or not. When you really think about what the CCJ would have decided today, is the antithesis of rule of law. It is strange that they would have come to such a conclusion, because you could actually contemplate situations, Sherrod, where a party could win an election petition could be filed, the election petition could be based on a number of fraudulent acts, as in this case, and simply the judge dismisses the election petition. What the decision today really does is to insulate and protect a party that comes to power by fraudulent means. Because the minority judgment, which is in fact a dissenting judgment and is a very strong dissent by Justices Barrow and Jamadar, in which they're saying that the court must have the power to check to see whether this happens. And the court is saying that this is merely not something that should be considered as a matter of course, but that the law specifically provided for it. Now, when you look at the judgment, could I continue, Sherrod?
Go right ahead, Senior Counsel.
Well, when you look at the judgment, I believe that there was a fundamental disagreement among the 5 judges. It may have explained why we took so long to get the judgment, but it was clearly a fundamental disagreement among the 5 judges. Justice Barrow, for example, stated that the starting point of the consideration for the issues in this case for him was Article 163(4)(d) of the Constitution, a provision which empowered Parliament to pass legislation to provide for the practice and procedure in relation to election petition matters and election petition jurisdiction conferred on the High Court. And insofar, the Justice Barrow is simply saying that Section 42 of that Act, which provided the High Court with the power to treat an election petition as an ordinary matter, meant that when the court treated it such as an ordinary matter, that an appeal, in his opinion, existed, a right of appeal existed. And then they disagreed that you should not have gone to the Court of Appeal, But fundamentally, both judges agreed that in those circumstances, the right of appeal existed and it lay to the full court. The majority or the three judges never any argument in relation to 164 3D at paragraph 70 or so, I believe, of their judgment. They simply said that they adopted an approach which simply meant that it must be construed strictly. And the implications of that sort of approach is very significant when we see the consequences of it. Justice Jamadar spent significant portions of his judgment trying to explain the importance of interpreting the Constitution, and in a very expansive way, in a way that is consistent with what is required. Justice Jamadar went so far to say that Guyana intended for you to have a right of appeal. He said so expressly. This is what Guyana wanted. Guyana system wanted you to have a right of appeal. But the majority justices felt different. So this is where we are. I don't believe that we can say that we're at the end of the resolution of these issues one way or the other. I believe that Mr. Selwyn, my good friend, Mr. Peters, and the other counsel involved in this matter will have to make some serious reviews, considerations in terms of where we go forward in terms of the decision made today. I believe that this decision will stand as a blotch on the record of the CCJ with the greatest of respect. I believe it represents an irresponsible diversion from the very progressive path we've been seeing the CCJ making over the years, especially in relation to decisions in relation to Guyana, its constitution, what our constitution means, electoral reform is needed. This decision stands out as not in keeping in the same vein of progressive jurisprudential thought, especially that you would expect from an apex court in 2022. You know, I believe Justice, one of the law lords, his name, I can't remember, it's either Lord Diplock or, I believe it's Lord Diplock in the case of Fisher against the Attorney General of Bahamas, a very well-known case. The court said that Privy Council said that interpreting the Constitution, it must not be interpreted as a tabulated legalism. And it was interesting to see in Justice Jamadar's judgment that he resorted to that sort of language to show the restrictive interpretation that was being placed on the Constitution and the law governing this matter that rendered the entire process inconsistent with the very purpose of the court, which is to supervise electoral matters. You saw, I want to bring to the public's attention, you saw in the case of Ali against David, where the CCJ decided that it assumed jurisdiction when the Constitution specifically said that the Court of Appeals decision was final.
That's
and
what's
in this
startling to me.
circumstance,
That's the case I was trying to remember. It
Yeah.
was quite startling. The Constitution in that case, Ali versus David, specifically said, there was nothing beyond the Court of Appeal locally, and the CCJ clawed its way back to jurisdiction using all kinds of mechanisms and gymnastics.
Yes, I believe that this decision is going to come in for some serious criticism in the legal world, both by other courts around the world, and I believe by academics abroad in the region and around the world. It's quite the sort of decision you would not expect from an apex court in 2022.
Selwyn, you wanted to add anything there? Attorney Peters?
Well, no, I think Mr. Ford articulated Very well. The substance of the decision. I think people wanted to hear substantively what the court said and how it reasoned to get to the result that it did. And I think, I'm confident that Mr. Ford did a very good job in articulating it. And obviously, he's right. These things, these cases where the right to be heard has been taken away from the petitioners in such fundamental issues does not augur well. And I agree with him.
Very well. Attorney at Law Selwyn Peters, Attorney at Law Senior Counsel Roger Ford, thank you for spending this time with us and making sense of this for our listeners and our viewers.
Yeah, folks, we couldn't put it any other way ourselves. And we thought it would be useful for you to hear that back again. I was spellbound. I was there asking the questions, and I was missing my cue so many times because I just wanted to soak up on these guys were saying, they practice law every day. And as Attorney Law Peter said, they practice at that very, very high level. And I'm so grateful. I'm so grateful you have them on the team. Both international lawyer Selwyn Peters and senior counsel right there for who made a lot of sense last evening as they expounded and elucidated on all of those technical legal issues if you really depend on them for insight and for guidance. True then.
Right, I think that after Selwyn Peters and Roger would have put it out so candidly, I don't think there is any question as to the details of the case. But I think one of the most important thing I could gather is, when Attorney at Law Selwyn Peters was speaking there about the fact that he not only practiced in Guyana, he practiced in Trinidad, he practiced also in Canada. He was saying that it will never pass.
Yeah.
That will never be accepted. That explanation that was given,
the foolishness, the nonsense,
would never be accepted.
Yeah.
It just goes to show that we just accept utter nonsense here in Guyana. And he made a very, very profound point when he said, even though the program is using the news that the Attorney General does, that when his colleagues look at it, they're like scratching their heads. You can't believe that is the Attorney General, and the content there that's on the program, that basically those things would have been grounds for his resignation to be tendered.
Yep. Thank you, there. Attorney at Law Gary Selwyn Peters, Attorney at Law Wednesday Ford Senior Counsel, International Lawyer Selwyn Peters, mind you. And that's going to do it for us at this end. Can't add anything else to that, folks. Stay tuned. Encourage you guys to partner with us. Every cent you guys submit to us goes back to building these programs, producing them, publishing them, and make sure you're having valid, credible information. We want to thank you for your love, your support, and your generosity. We're delivered by the Cash App, Zelle, PayPal, MMG, MoneyGram, and Western Union. Folks, let me tell you something. We need every penny. We need every penny. Thanks for joining us. That's going to do it for us at this end, folks. Take care. We see you guys back here this evening. We're
Pashwe night.
Yeah. Thanks for joining our international podcast a little bit. Remember to share the podcast, folks. Share the programs so that others get valid, credible information. We're in our third season, and every season is 100 episodes. So if we return one, we are 300 episodes, and if we are episode 53 in the third season, we have done 350 podcasts to date. And every podcast represents an hour of your time. 350 podcasts, 53 we've done. That's where your funding goes towards. Valid, credible information, folks. Partner with us, share like, smash that emoji button. I will do everywhere, folks. Take care. He has the final word.
Well, thank you so much for joining us, guys. This bit, particularly the comments coming there from Roger Ford and Selwyn Peters, invaluable information. And I have to say that we continue to be extremely proud of the work that both of them are doing. They are phenomenal individuals altogether, and their character, very much intact we'd love to have the discourse and the discussion with them. Guys, we're going to continue to be bringing you information and bringing the conversations that put everything into perspective as you just had it there. So I don't think there's any questions that you had that was not answered by those two gentlemen, very esteemed learned gentlemen. So I hope that you would be able to take that information now and to take it into your everyday conversation to persons that may not have been able to listen to the program, your neighbors, your friends, your family, or let them have a good understanding of what went on, the gravity of the situation by that post by the Attorney General there and his entire office now being questioned when it comes to confidentiality, whether or not there is any confidentiality. The fact that even at the level of the CCJ, we are left now to wonder if they're going to be revising their policy when it comes to sharing those information, very sensitive information, because
in light of what Anil and the Attorney General of Canada, in light of what he has done.
Correct. That's the position that we're in, guys. So continue to ponder on those facts and have a good day.